Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm a presiding judge here in County Court at Law number 2. You have been asked to come to court this morning because you have a case in this court. Your case is set on what is called the arraignment docket. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have is a misdemeanor. Now, a felony case is commonly referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they are not serious. It just means that they are not as serious as a felony case. And when I use the term serious, when I'm talking about the facts and the possible punishment range that a person, or the possible punishment that a person can receive if they are convicted of an offense. Now, your felony cases are divided into 5 categories. We're going to start at the top. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, if you have a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. If you're convicted of a third degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, the case that you have is not a felony case, it's a misdemeanor case. Misdemeanor cases are divided into 3 categories, and we'll start at the top and go to the bottom. The highest misdemeanor is a Class A misdemeanor, then we go down to a Class B misdemeanor, and then we go down to a Class C misdemeanor. Now, your Class C misdemeanors are those offenses that occur, that are normally heard in the Justice of the Peace Court or the JP Court or the municipal court. For example, speeding tickets is a Class C. Now, wearing your seatbelt is a Class C. Now, the range of punishment for a Class C misdemeanor is fine only. You cannot be given jail time for a Class C misdemeanor. However, if you fail to pay the fine, or if your fine is converted to community service and you fail to complete the community service, then a capious pro fine can be issued. A capious pro fine is a warrant for the fine, which means that you could be required to sit out the fine if you do not pay the fine or if you do not perform the community service. Now, if we go up to the next misdemeanor, it's a Class B misdemeanor. Range of punishment for Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as I mentioned earlier, there's some information on that clipboard. The information that's on the clipboard concerns one of the rights that I'm going to go over with you. Now, as a defendant in a criminal case, as I mentioned earlier, you have rights. One of the rights that you have is a right to have an attorney. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. As a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, you can represent yourself, but before you can represent yourself, you have to waive, which means to give up your right to have an attorney. If you waive your right to have an attorney, or if you give up your right to have an attorney, then you can represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date. In essence, you'll be given time to hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, you will need to fill out a financial questionnaire. Now, on that tablet that you have, the financial questionnaire is the document that is titled Jefferson County Affidavit of Indigence. You would have to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you desire to represent yourself, you may not speak to a prosecutor. The prosecutor is an assistant district attorney. Now, we have 2 in this court right now. They're sitting in front of you at the table in front of you. You will not be able to speak to a prosecutor unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver should be the second document on that tablet. It's titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And I will go over that document with you just in a few minutes. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is, if you decided that you wanted to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire your own attorney, you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney or to give up your right to have an attorney to represent you and to represent yourself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then at the bottom of this document, on the line that is titled defendant, you will sign your name on that line, and then you will date it today's date on the line that is titled date, and today's date is October 24th of 2023. Now, on the next page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding a Trial. Now, if you're waiving your right to an attorney and you're desiring to represent yourself, you would have to read and sign this document. And this document reads as follows. I've been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. And that's when you say voluntarily, what you're saying is that no one is forcing you to do this. You're doing it of your own free will. And when the word intelligent, when that word is used, it means that you know what you are doing. So you're saying that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 24th day of October of 2023 by County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to afford counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you would date it today's date on the line that is titled date. Now, as a defendant in a criminal case, as I mentioned earlier, you have rights. The first right I went over was your right to have an attorney. Next right is you have a right to have a trial by jury. When a young lady is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors on your case. They will listen to all of the evidence. They will listen to the arguments, and then they will deliberate. After they deliberate, they will decide whether or not to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. That simply means that you have a right not to have a trial by jury. Now, if you waive your right to have a trial by jury, your case will still come before the judge in one of 3 ways. One way it would come before the judge is by way of a trial, by way of what we call a bench trial. A bench trial is a trial by judge only. The judge will listen to all of the evidence, listen to the arguments, and then the judge will decide to find you either not guilty or guilty. You also, the next way your case will come before the judge is by way of an agreed plea bargain agreement. And a plea bargain agreement means that you and the state have reached an agreement to settle your case. If you reach an agreement with the state or with the district attorney to settle your case, then that case will come before the judge. And the judge can either accept or reject your plea bargain agreement. If the judge accepts your plea bargain agreement, then at that point, if you decide that you would like to appeal your case, what an appeal is, it means that you would like to have a higher court to review your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. Now, if the judge follows the plea bargain agreement, and if you want to appeal your case, you have to get permission from the judge. If the judge gives you permission, then your case will go to the Ninth Court of Appeals, which is right above us on the 3rd floor. They can do one of 2 things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then at that point, you can appeal it to a higher court than the Ninth Court of Appeals. The court that you will be appealing it to is the Texas Court of Criminal Appeals, located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what we call a pro se petition for discretionary review. Now, pro se means that you'll be representing yourself. And your petition for discretionary review is you'll be petitioning the Texas Court of Appeal to review your case to see, one, whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you've been wrongfully convicted. Now, if they grant your pro se petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send it to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that time, your conviction will stand. All right. Now, you also have a right to have witnesses to come to court. That chair that have the microphone in front of it, we call it the witness stand. And what witnesses do, they can come to court, they can testify for you or against you. If you have an attorney, if you represent yourself, questions can be asked of the witness. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. And basically what that means is it means that you will not be calling witnesses in your case. It does not mean that the state will not be calling witnesses in your case, because they will be calling witnesses. Now, you also have what we call a Fifth Amendment right against self-incrimination. What that means is you have a right not to say anything. You have a right not to testify in your case. The state of Texas, the government, the district attorney's office cannot force you to testify in your case if you invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And by doing so, you will be testifying in your case. You also have a right to have what we call discovery. Discovery basically means that you have a right to see the evidence that the state has against you in your case. In essence, you have a right to discover the evidence. And when I'm talking about evidence, I'm talking about witness statements, police reports, your statement, documents, lab reports, videos, audio recordings, any instruments that they'll be using in your case as evidence against you. You have a right to have access to that evidence by having discovery. Now, you can waive or give up your right to have discovery, and if by doing so, you will not be having access to that information because you've given up your right to have access to the evidence that the state has against you. Now, everyone here today for arraignment, you were arrested, you were in jail, you bonded out, you either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you did not pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear in court. Now, every day that you have spent in jail, that jail time can be used as credit towards your punishment. So for example, let's say you have spent 5 days in the jail, and let's say you and the state have reached a plea bargaining agreement for you to serve 5 days in jail. Well, what that means is you will not be required to serve any more time in jail. Why? Because you've already served 5 days in jail, and therefore you'll be given credit for the time that you have already served. Now, if the state is offering you to serve 7 days in jail, and you've served 5 days in jail, that simply means you will only have to serve 2 more days in jail because you'll be given credit for the 5 days toward the 7 days. Now, every day that you spent in jail can also be used toward the payment of fine and court costs. You get $100 per day that goes toward your fine and court costs. So for example, let's say you spent 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, that simply means that you would not have to pay the $500. Why? Because you spent 5 days in jail, and therefore the 5 days in jail is $500. And so the fine and court costs will be taxed and retired. Now, if they offer $700 fine and court costs, you spend 5 days in jail, that means you would have to pay $200. Now, if you cannot pay the $200 on the day that you enter, that the case is disposed of, then we can put you on what we call a payment plan. In essence, you can pay off your fine and court costs in monthly installments over a period of months. Now, some people may not be able to pay off the fine and court costs over a period of months because they may not have the income. That's not a problem either, because the law allows the court to convert the fine and court costs to community service. And what that means is every 1 hour community service that you perform in a nonprofit organization, $12.50 will go towards your fine and court costs. So by example, if you perform 8 hours of community service, that's $100 that will go toward your fine and court costs. So in the scenario that I just gave to you, a person owed $200, they work 16 hours, which is 2 8-hour days. That's $200 that will go toward the fine and court costs. Okay. Now, Jefferson County has a program that is called, when I say Jefferson County, I'm talking about the district attorney's office. The district attorney's office has a program that is called pretrial diversion. Pretrial diversion is a program where they will dismiss your case and you can get it wiped off your record. We call that an expunction. The way the program works, you have to be your first offense. You cannot have a criminal history. So if you haven't been in trouble before, the second requirement is it cannot be for an offense of resisting arrest or unlawful carrying a weapon. And then third, you have to get an attorney to assist you with making an application or writing a letter to get into the program. Now, as I mentioned earlier, if you get into the program, your case will be dismissed and you can get the case expunged, which means wiped off, deleted, or erased from your criminal record. Now, in order to qualify for that program, as I mentioned earlier, we have applications here, and you can get an attorney to assist you to get in the program. You have to be, you can't have a criminal history, and it cannot be for an offense of unlawfully carrying a weapon or resisting arrest. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program, which is called Veterans Court. This is just like the previous program, the pretrial program that I mentioned. With the Veterans Court, once you get into the program, you complete the program, the case is dismissed, and you can get a non-disclosure. And what a non-disclosure means is we cannot disclose to the public that you had this case and that you were in the program. So in essence, it's like having your record sealed to the general public. Now, the government, governmental agencies can have access. The school districts, school, police departments, governmental agencies can have access, but the general public cannot. Now, this court has a program that is called the CSI program. CSI program stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017. So for the past 6.5 years, we've been having this program. And the way the program works is designed to address the issue of what we call recidivism. Recidivism means people commit crimes over and over. And so the way we address recidivism is through the Community Safety Initiative. And with that program, we have partnerships with agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. And the people, the folks that's in the jury box, they're from Spindletop. And with the Spindletop Center, with that program, what they will do, now Spindletop is, as I mentioned, is our local mental health center. A person could get in the program, they don't have, you don't have to be insane or incompetent. You can merely suffer from depression, anxiety, or any host of other mental illnesses. And Spindletop, they will conduct a private interview. They will do an assessment and develop a treatment plan to address whatever mental health needs that you have. Spindletop also has a program that's called ATAR, and a local drug and alcohol council has a program that is called OZAR. Both of those programs are programs designed to address the issue of drug and alcohol addiction. What they will do, they will conduct a screening, have an assessment, and develop a treatment plan to address your alcohol or drug needs. And all of these programs, as I mentioned earlier, these programs are a part of our CSI program. Now, if you are unemployed and do not have a job, or if you have a job looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. In that program, they will not only train you in any one of those areas that you select, but they will also assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get your high school diploma, or you like to get a GED, well, the CICE program has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything but time. And in this code, I like to say we don't just give time, we take our time. And the reason why we take our time is because we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And we believe that if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so, therefore, I always say that when you come to County Court at Law Number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in the lives of the individuals that come before this court, we'll also make a difference in the home that they live in. And if we make a difference in their home, we'll also make a difference in the community, because what goes in the community comes out of the home. And so, as I mentioned earlier, in this program, if you're interested in this program, just please let us know. And the other interesting part about the program is this. All of these programs that I've just mentioned to you can be used as community service. So, for example, let's say you had to pay a fine and court costs, but you couldn't pay your fine and court costs, and it's converted to community service. And let's say you wanted to address your mental health issues or your drug or alcohol issues, or if you wanted to get a GED or you wanted to, get some job training. While you're in any one of those programs, every 1 hour of, let's say, job training that you do, $12.50 will go towards your fine and court costs, and 1 hour will go toward community service. So in essence, you're doing one thing, but you're getting credit for 3 things. You're in the program, you're getting 1 hour community service, and you're paying your fine and court costs. And so, as I mentioned earlier, all of these programs are free. Now, I also mentioned to you that we have some individuals from Spindletop. They're going to come to you right now and tell you a little bit about this program that Spindletop has to offer. At this time, we have Deputy Hinton and Gabby. They're from Spindletop. Deputy Hinton and Gabby.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed state admission Your office. This is my coworker Gabby. Gabby is a qualified mental health professional. The reason we are both here this morning is the judge is gracious to provide this in this courtroom because he cares about every single person. The judge has found, once statistics prove, that some of the technical issues commonly have mental health needs, substance use disorders, or sometimes just the lack of resources to help you with your particular situation.
So we need to mental health, it can be things like anxiety, of course, and depression, chronic sadness. They can also mean other factors like financial stress or lack of support in your house or lack of support being here, that by being in court, it doesn't help. On top of everything that's going on in your life. So that's what we mean, we need support with us, being in the courtroom, housing benefits other than mental health. All.
Maybe this is your first time to be in court, maybe it is your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. You need to share that need with us. And Gabby's gonna explain to you how you can do that very privately. We're not here to embarrass anyone, but we will need that information to see how to serve you and help you.
So the document I gave you when I walked in, this is protected, only the person, the only person that's gonna see this, and another person who's gonna reach out and contact you is me also. And so any information that goes in here is private. For this, we made it very simple. It looks overwhelming a little bit, but simple right here as the most important thing is just resources needed. You can check which box you want on here, and that's one of the most important things we need for today. And if it's not listed on here, you can fill it in also down here. And also give us your phone number, name, date of birth. That is one of the most important things. So we can contact you. And the method I'm gonna contact you is I'm gonna send over the text. If you don't receive text, you just let me know, and you can try and give you a call. But I'll send over a text, and the ship allows me to contact you for it. And I've got a robocall or anything like that. It's just reaching out, seeing what resources you need. And if you would like to talk to them, also there's an option.
Also have a flyer here that I want to hand everyone here before we leave. On the back, it tells you some of the advantages of participating, but on the front, it also has a 1-800 number. If you ever find yourself in an unsafe place, you can call that number and get help you need. Just shortly, the court's going to go into recess. When it does, we'll come out there and we'll be able to visit with you. We'll pick up those forms that you completed, and I'll hand this flyer to each and one that.
And also to know, I know there's a lot of supporting family members here. It's not just for the people who are here, it's also for family members.
Thank you. Thank you, Your Honor.
Thank you, Deputy Hinton and Gabby. Now, ladies and gentlemen, the paperwork that you have, if you need any assistance with filling it out, we have our court personnel who here will be happy to help you. When we go into recess, if you need help, just raise your hand and we'll have someone to come out to assist you with filling the paperwork. Now, it's going to take us some time once the paperwork is filled up to go through the paperwork. And once we go through the paperwork, we're going to call you up before the bench, in front of the bench, one at a time. And once we finish here at the bench, you'll have a seat and then you'll go to our court coordinator's window. Your case will be reset and you'll be free to go. Now, as I mentioned earlier, this is going to take us a little time. If you need to use the restroom, there are 2 restrooms right outside the door. The men's restroom is in front of County Court at Law number 3, and the women's restroom is in front of the 172nd District Court, which is across the hall. As I mentioned earlier, that's where the women's restroom is located. So now do not leave the courthouse, because if you leave the courthouse and we call your name, and you're not here, your bond will be forfeited. If your bond is forfeited, a warrant will be issued for your arrest. So at this time, the court is going to go into recess to give you time to fill out the paperwork and then give us time to assist you in filling the paperwork out, and also to give the Gabby and Deputy Hinton an opportunity to talk to you and tell you a little bit more about the program that they have at Spindletop. So at this time, The court will be in recess.